Alright, this is Trace, and let me show you the contract that I use when buying a property. Okay, but before I do that, a little bit of disclaimer here. So number one, I am not a lawyer. So what you're about to hear and see, you should not construe as legal advice because it's not. I am not qualified to give legal advice. And so, number two, you should always seek a lawyer for legal advice. Okay, especially when you have a contract between you and another party, you should always get legal advice when doing that. Okay, I don't want you to get into trouble. I don't want you to violate any laws or have you use a contract that doesn't really protect you. Okay, so this is what I use. You can use whatever contract to sell format that you want. It's up to you. Okay, it's up to you and the advice of your lawyer. Okay, I'm just showing you what what I use. So the first part, well, I for confidentiality purposes, I block out the name of the seller and the address. Okay, but this is what I use. So in fact, I just talked with the seller today, and we agreed on the purchase price. So today is July 27. So I do this stuff even today. All right. So this contract to sell executed between the two parties. The first party is the seller. Okay, and the second party, that's me, that's the buyer. All right, and collectively they shall be referred to as parties, and that whereas the first party is the owner of unit 209, building whatever, which I block out. Okay, and you can put the title number in there as well, and that's the property that you're talking about. You need to mention that. Okay, and that the second party, that's me, has offered to buy the said property, and the first party has agreed to sell the same. Now, therefore, these are the provisions. Provision number one stipulates the purchase price, 1,600,000 pesos. Alright? And I add in here that the first party shall pay for all the closing costs. Okay? So, whether you can get the seller to agree to that or not, it's up to your negotiation skills. Alright? So, it's up to you if you want to put it there, but I put it there, and I have the seller read that through, and if the seller has a question, I'll openly answer, that, hey, I want you to pay for all the closing costs. Okay? So, do you have a problem with that? If there is, then we negotiate. We negotiate on the purchase price, or we remove the provision. So, it's up to you. It's up to your how motivated the seller is, and it's up to the deal if the deal will still make sense if you pay for the closing cost. Okay? And that provisions number 2 to number 6 of the contract are your contingencies. Okay, contingencies are your way out of the deal if the deal does not make sense based on your due diligence and based on the assessment of your buyers. Okay, so for example, provision number 2 states that the purchase shall be contingent to satisfactory inspection of the property by the second party, conducted by the second party itself or its contractors, inspectors, assignees, or partners. Okay, so meaning that this gives you the provision to inspect the property yourself, or show the property to contractors, or show the property to your potential buyers. So that is where the assignees, okay, the word assignees can be anyone that you want to assign the contract to, and that includes your buyers. Okay, now if you're not satisfied, you or your partners or assignees are not satisfied, then the purchase is declared null and void. Okay, so that allows you to get out of the contract if in case based on your inspection or inspection of your buyer, the deal does not make sense. Third provision, that the purchase shall be contingent to satisfactory assessment of the value of the property as per the sole determination of the second party. If you're not satisfied, then the purchase shall be declared null and void. Meaning that, for example, if based on your preliminary assessment, the value of the property is 3 million pesos, but based on your more detailed assessment, or let's say you were able to get an appraiser to do an appraisal of the property and the appraisal is below 3 million, let's say it's only 2 million, and based on that the deal will not make sense, then you can get out of the contract. Okay, that's why I put it in there. Number 4, that the purchase shall be contingent to satisfactory legal review of the title, tax declaration, survey, and other pertinent legal records of the property submitted with the first party to the second party. So if you're not satisfied with the documentation, all the legalities, especially the title, which is very very important, then you should be able to get out of the deal. And then provision number 5, I have this put in by one of my lawyers, but basically it gives you, okay, this makes the deal confidential, okay, that both parties will not you know disclose to other parties, okay, uh, confidential information, which makes sense, okay, and that the first party, okay, agrees not to circumvent the second party by directly contacting or transacting with any potential buyer introduced by the second party. So if you have a buyer, okay, that means the seller shall not go around you and go to your buyer directly. If not, then there will be, that the first party shall pay you for losses and unearned fees, profits, or commissions. All right. So that's very very important. That assures you that that your buyer will not go around you and go directly to the seller. Okay. And that lastly, that the purchase shall be contingent to satisfactory approval of the second party's assignees and or partners. Meaning that if your buyer is not satisfied, for whatever reason whatsoever, then you can, uh, you know, you can get out of the deal. All right. So with that, again, this is the contract to sell that I use. It's up to you to use your own version of it, or as long as you consult a lawyer to get you a contract to sell that you can use, then do that. All right. Because it's very very important that you seek legal advice before doing any investing or before signing on any contract, to ensure that you're protected and you can get out of the deal and the deal does not make sense based on your due diligence, and to ensure that all your rights are protected, and you can get a good deal without putting yourself, without taking on unnecessary risk. So in the last ever Think Rich Quick seminar, my last real estate seminar ever, I'm going to discuss all the contracts that I use. Okay, the contracts that I use when buying. Okay, because the contract to sell is just one of the contracts that you can use. Or okay, when buying a property, this is just the preliminary stage. When you're closing on the deal, there's another contract to use. Okay, so we will go through that in detail. How I write the contract to sell when selling a property will be very very different than the contract to sell when buying a property, to ensure that now you as the seller, you'll be able to protect your rights. And then lastly, I have contracts that I use when raising capital. Okay, so again, those are different contracts, and we will go through those contracts in detail in the last ever Think Rich Quick seminar. So I will see you at my last ever real estate seminar.